us about. But Yonca, before that, you have to tell us about yourself, and then we'll go to the book.
Thank you so much. Good evening, or good afternoon, or good morning, dear colleagues. Firstly, I would like to extend my special thanks to Mediator Vikram regarding the valuable organization for me, because this chance is a valuable chance for introduction of our book, and for that reason I'm here. I'm a certified mediator and arbitrator and attorney at law. I'm also given a lecturer on LLM program on digital finance and banking law, Istanbul Gedik University Law Faculty. I am the partner of the Yücel International Law Firm and Mediation and Arbitration Center. And I am also the national short-term consultant for European Council ADR project in Turkey. And I can say lots of things regarding me, but I'm sure that you are so excited to listen our book, which it contains, and which the book contained the different topics, and which authors will gonna write these articles. I'm sure that you are so excited. For that reason, I don't want to mention myself. And
okay, so this is the book. This is the book that we're discussing under the cooking books.
Yes.
This is a series.
Yes.
But you want
Thanks again.
Yeah, want to tell us about the authors that are there?
Yes, absolutely. Concerning our book, especially, let me share the story, vision, and mission of our book with you. I am thrilled to introduce you our UIA LexisNexis Publication Collections Collective Authors Book, Volume 11, titled Commercial Mediation in the Digital Era, published by LexisNexis 3 months ago. You can follow our link. I think our link a little bit.
They'll find it in the post. The post is there on social media.
And the table of contents, the second slides of our book. And in this context, let me express my thankfulness to my exemplar teams, which includes Professor Nadja Alexandre, Zoe Giannopoulou, Amanda Bucklow, Thomas Valenti, Mauricio Gomm Santos, Alexandre Simões. In my opinion, Alexandre will join us, I think 2 or 10 minutes later. Federico Antich, Rahim Shamji, Azubike Okoye, and Yoshihisa Hayakawa, Thomas Gaultier, Vakhtang for their great commitments, professionalism, and fantastic jobs. And I'm especially grateful to UIA president, past president, and new president named Uruguaya de Palacio, UIA Publications Director, Administrative Director, and sales representative of LexisNexis for their inspiration, interest, support, and production of this book. In this book, I confess both regulation proposal on European Parliament on artificial intelligence and ABA rules 2022 were trigger for me while forming the thought of writing this book in this first step. Thus, when I return to mention regulation and rules, I want to emphasize that online dispute resolution has revolutionized the digital space. With the growth in technology, systems are advancing daily. More advanced technologies such as artificial intelligence, machine learning, and cloud computing have been integrated into ODR systems in a bid to improve its reliability. The use of such technology has steadily impacted the legal and judicial sectors. The process has offered creative solutions within a brief period, making it quicker than traditional dispute resolution methods. Highlighting the point that ODR is also more flexible and offers real-time outcomes. Therefore, there is a need for organization in the digital space and every platform to consider inclusion in their operations. Ladies and gentlemen, apart from this issue, I would like to inform you that USA DOT adopted 5 code of ethics principles as responsible, equitable, traceable, reliable, and governable for artificial intelligence a while ago. Considering above point of views, an extensive, complex mediation comprising various participants and experts from different countries and time zones may have not been conceivable via remote mediation up until this point, with possibly few exceptions, or at least smooth deployment could not be guaranteed throughout its entire process. However, with careful planning and protocols and the advances in technology that have taken place in recent years, witnessed particularly during the COVID-19 pandemic, such mediation is now conceivable. Secondly, at this stage, especially, I want to mention about how I formed the table of contents of our book and meet the authors in the last January 2022.
But before that, Yonca, you have to tell us how this book, how did you think of it, or did you think of it? How did it come up? So let's start with the basic. You were into your speech today.
Yeah. You know, just on time. And could you please reflect the table of contents, if it is possible? Yeah. Okay. For this purpose, authors from 11 different countries in Europe, Asia, North and South America have gathered to write this book, directed at ADR practitioners, such as commercial mediators, mediation advocacies, and relevant parties from commercial sectors. Returning to my initial point, when I set out the table of contents, I thought we might raise all aspects of commercial online mediation, and Amanda, Mauricio, Azubike, and Thomas Gaultier decided to accompany with me by their valuable articles during our project. Hi, Alexandre.
Let's say hi to Alexandre first. Hi, Alexandre.
Hi, I was following.
Welcome.
Yes.
Yeah.
I received a message. I was following you in the other platform. Then I realized that I must be here to participate. But let's go on.
Okay.
Thank you, Vikram.
Your line is so closer. Okay. Then Federico and Alexandre proposed me to share their own online platform experiences and applications. Additionally, Zoe and Rahim brought new proposals regarding ethic rules in online mediation and whether online dispute resolution be used as a tool to access to justice, which have not been stated in detail before. Furthermore, Mind Talks, Thomas Valenti, Mind Talks crossed with Thomas Valenti talks related to artificial intelligence in mediation, as you see that the title of article, Reflections on the Use of Artificial Intelligence in Negotiation and Decision Making. Thus, he accepted my offer. And lastly, I finalized our table of contents since Mrs. Professor Nadja, Alexandre, and Vakhtang Georgi accepted to write an article related to Singapore Convention on Mediation in the Digital Era, and Yoshihisa Hayakawa, Professor Mr. Yoshihisa Hayakawa, adopted, as you see that, sui generis approach for introducing institutional of international online mediation rules. As you see that, the name of article, International Rule-Making Activities for Resolving Disputes Using ODR. Regarding my explanations, I'm pleased to inform you that our book presents broader trigger perspectives and techniques about the mediation process, which includes preparation, ethic rules, using mediation styles, negotiation and bargaining, role of parties and counselor, and settlement via either prestigious authors' knowledge and experiences or sample ODR platform rules and application, such as Italian and South American during the commercial online mediation. Moreover, it seeks whether artificial intelligence may be used during negotiation and presents how to build decision tree analysis, including risk and cost and benefit analysis for banking, financial, and other commercial disputes. Lastly, it introduces international rulemaking activities, enforcement procedure for mediation settlement agreements in the digital era, within the shadow of Singapore Convention on Mediation, and questions whether it creates access to justice via online dispute resolution. At that point, I would like to suggest our book for all mediators, advocates, and the parties who will be involved online commercial mediation. Apart from this, I emphasize that we realized the 3 series of introduction of our book successfully, with kind contributions of Federico Antich, Alexandre Simões, Zoe Giannopoulou, Rahim Shamji, Mauricio Gomm Santos, Azubike Okoye, and Thomas Valenti, via different online platforms and host institutions, ADR centers. Today, I will continue the introduction of our book with kind contribution of Alexandre Simões and kind host of Mediator Vikram. Due to others have business obstacles, for this reason, I want to turn to Alexandre for introducing his article. Alexandre, Zoom's floor is yours. Thank you.
Look, Thank you very much, Yonca.
Yeah, Alexandre, first have you tell us about yourself. Yeah, then, of course,
okay.
Then we move. Yeah.
I'm a lawyer and a certified mediator in São Paulo, Brazil. And I had the honor to be invited by Yonca with another colleagues and the assistance of LexisNexis and UIA, the União Internacional de Advocados, to write a book. And this invitation came in a moment that we all lived the pandemics, the coronavirus 19. So my part was to produce chapter 4 and explain from the Brazilian perspective, using the mediation more frequent online. What's critically different about the process in mediations online? And so I have a Brazilian perspective. I bring you here a Brazilian view, but I think that this view is quite universal because what happens in my country, in our area, in our continent, is maybe not so different of what happens in the other parts of the world. We all knew that we could have been working more with online platforms as we are doing now in this event. But most of us were postponing this. We knew that it would come, but we were not so keen on getting it right now. And the pandemic came and obliged us to do this quick change. So from a moment, we need to go to the online world. And what happens? We need to create new rules. In the Brazilian offices, lawyers' offices, or institutions of mediation, in the presential phase, we were supposed to go to the place, stay waiting in a room. Some people put us in the reception. Some people prefer to put us in the meeting room, but the part is separate, and they serve a coffee. In Brazil, it's very common to serve coffee and bread, cheese, and we wait, we talk, and we had a lot to do to do presential, a meeting. When the digital world came, it changed all the paradigms in Brazil. We Brazilians are not as the British or the Turkish or the Indians or many others colleagues from around the world that are punctual. So punctuality in Brazil is something very relaxed. And when we come to the online dispute resolution, we need to adjust that and become again like a Swiss watch. The hour is the hour. You need to come for the hour. And if you don't come, you need to explain yourself in the plans B that you must create when you are using a platform. For instance, we can have a problem of connection. So it's good practice now to say, if something happens, please call this number, use the WhatsApp, exchange messages, use the mail, so we can understand if it's possible to wait a little bit for the connection to be reestablished, or if we're going to need to postpone the meeting for another day. When we are presential, we are reading the people that are in the meeting with us, seeing the face, the weight, the height, everything. In the virtual world, we are so far close to the squares that we are. So we see from a position only. So the reading of body language is not so completed as the presential. But we need to adjust our tools of communication. We must pay attention to the rhythm, to the tone we use, and the mixture of communication, oral communication, written communication using the chat, using how to exchange messages, and a new etiquette, a new way to behave. Because, for instance, I'm with a background of my city, São Paulo. Many prefer to choose a blur effect. So you are in your house, for instance, and you just blur the background. So if someone comes, because what we saw during the pandemics is invasions of the platforms. So this one now is secure. It's broadcasting, but nobody can come in unless they have the security numbers, everything that Mediator Vikram gave us. So it's a safe environment. And for mediation, this is key, because we need to take the participants to a place that is safe, that they can have the confidentiality, the secrecy preserved. So the platform brings us that. We learn by mistaking. So in Brazil, we have a lot of cases, I think around the world the same, of, for instance, judges coming to a session, but the platform was being used by a grandson, and the grandson put the background of a shark. So the judge is in the session, in a formal session, with a shark swimming around and take the confusion. And this is very important also because when you choose the space, look at Vikram. Vikram, for instance, is in a place with neutral colors and two objects behind him. So if you not pay attention to Vikram, you are going to see and try to understand what are the objects that are in the background. Yonca choose also a nice place. We have a small spot of a light on the top of her, because this is how we are going to communicate it. So the position to be near the computer. If you want to look at someone's eyes, you need to look to the camera. If you speak looking for the camera, you gave the impression that you are talking, looking for the eyes of the others. So this is the difference. This is the kind of adjustments we need to make. And in my city and in big cities that we have in Turkey and India, for example, we are not losing more time in traffic. We are not losing more time looking for a parking space. And the daily agenda, if you have one meeting in the morning, one meeting in the afternoon in São Paulo, depending on the place you are going to go, the neighborhoods, it's impossible to do 2 meetings in one day. But in the ODR, in the virtual meetings, we can have plenty. Yesterday, I had 1 session of arbitration, 2 sessions of mediation, and another meeting online. And I went at night to give classes, presential classes in one university here in São Paulo. So it's unbelievable because you are gaining time if you are organized with the use of platforms. For instance, imagine that Vikram would have invited Yonca and me to talk about the book, to talk about our book.
Yes,
Sorry.
yes.
We need to, I would have it would be a pleasure, but I would have to take a flight to India, Yonca leave Europe to India, and we need to go maybe one day before to a hotel to have a rest, to take our legs back, the jet lag, and the meals. And then we are in India. Of course, we want one day or two to look around, to know some places and come back. So the other important issue is an economic issue. To do a meeting online in the international arena is much more easy. Of course, it's a coin. You have benefits, but if you flip the coin, you have the disadvantages. But I think this is normal for us. And the only mistake, I confess, maybe we committed in this book is not to ask Vikram to write something, but maybe we can do this, we can correct this in a second version, or ask him to send our comments about the authors each chapter. So for me, it was a surprise because it was I had the mission to receive one chapter, but when I have the possibility to read what our colleagues wrote, I said, we had the same fears, we had the same challenges, we had the same problems to solve. And this is, in my optimistic view, good, because when we join efforts together, we found solutions. And we see that we, in some aspects, we are different from each other, but we are in a global community. So we share a lot of things. So this book for me, I received as first a gift, an opportunity. When I wrote the article, I was a little bit sad because I was feeling that the pandemic costed so many lives around the world. But I think it was also an opportunity for us to learn from this terrible thing and to maybe give value to things that are more important in our lives. Good relationship, good persons, and that we, inside of each of us, we can take from us the peace that we all need and want. So I think we can have. And with that being said, of course, I would like to pass the floor a little for any comments from Vikram, because Vikram for me is like a person that represents very well mediation around the world, and he's like an ambassador of peace. He's always talking and joining with people to produce more debates on important issues. So this book celebrates what the digital era brought to us as many good aspects. I don't know if Yonca later on would like to talk about one very specific chapter, that the use of artificial intelligence.
Yes, yes.
We are deciding mediation. We are the mediators. We are the people that are working with the parts to find a settlement. But are we close to lose this position? And maybe we will have a robot, a chatbot, or an artificial intelligence giving the advices, giving the best decision. So this is something I put here to provoke. I strongly recommend that you read the book. So far, I think the book is only in English, but I have an impression that sooner, maybe we can have the possibility to then translate chapters or the entire book to other languages and to spread the message for more people. So thank you very much for this opportunity. And I pass the floor to Vikram and Yonca, because chapter 4 is of course, I'm the author. It's a very good chapter, but it's not the best chapter of the book. You must read the others. We have incredible contribution from the other authors, and I'm sure that Yonca can bring us some little tips or some little insights about it.
But Alexandre, you had such nice things to say about the work that I'm doing, but you have not been participating. All these discussions that we've been having, you've been working too hard. Like you said right now, you're doing 5 meetings instead of 1. So
yes, Vikram, you are right. I organize my agenda in a way that my priority now is my family. So yes. I have very little time for a quite big family. It's me, my wife, and 6 children. Two of them are married, one living in the United States. In August, another son will marry. So the family is becoming smaller, but the necessity to join is great. The second thing in my life is my office, so the profession. The third thing is one of that I like most is to teach. It's not the best payment, it's not the best fee we receive when we are teachers or professors, but it's very it's humanizing, it's very important. And a good teacher knows that when you teach, you learn more than the students, because you try to discuss or debate things with many other minds. So you give to the students what you have, but you receive many inputs from them. So for me, teaching is an activity that keeps you learning. And I pursue that for this reason. And then, of course, I would like to be the official translator of Vikram to Portuguese and Spanish, but it's the time left. But again, I'm doing my best. When I heard that Yonca would be here with you, Vikram, I did my best. I was only eight minutes delayed, but I came to the meeting because I said it's very important to say to my friends and the professionals that you are and I respect that your job is important regardless of my presence. I would be glad to be present, but when I'm not present, your work, your dedication is still worthwhile. So I pay my tribute to both Vikram and Yonca.
Thank you, Alexandre.
Thank you.
But Yonca, I think before you come in, you'll have to tell us about your chapter. But what I'm saying, Alexandre, about your teaching part of it, I think I'll have to create some skill development programs so that you can come and kind of teach. But I think maybe more about sharing your experiences and all that. That I think is an important thing. Yes, Yonca, what about your chapter?
Firstly, because I would like to extend my special thanks to Alexandre for his kind introduction. And as a matter of fact, I confess, because I and Alexandre met during the ADR-ODR International Mediation Competition and in online platform. What a lovely coincidence. And at that point, I do believe in online mediation and online training. Because I agree with Alexandre, I'm also giving lecture LLM program on Istanbul Gedik University via online, because I'm living in Ankara, but my university located in Istanbul. That's why I wanted to write this kind of book, and the lovely authors accepted my offer. Let's return to the another topics. Before my article, especially I want to explain the Thomas Valenti article, the titled Artificial Intelligence. Before his article, because I want to explain the some clue or some essential points of online mediation. For that reason, firstly, I want to introduce the Mauricio and the Azubike article, and then return to artificial intelligence. From the point of view, firstly, I mentioned about what the main concept of understanding online mediation is and how to redefine the roles of mediation. In this context, Mauricio and Azubike pointed out that especially the importance of confidentiality agreement and mediation agreement, and how to meet, for instance, just on time for both parties, considering the time differences within the framework of the role of mediator and lawyers. As you know, the Alexandre mentioned before, you know, we are the different time schedules, and especially the online mediation, we have to pay attention to time differences, and we have to switch our times to our mediation meetings time. And another important tool in the online mediation is how to build trust in the digital settings during the online mediation. Another important point goes to cross-cultural aspects and essential negotiation dynamics should be focused by Mediator under the Mauricio and Azubike article. As you already know that, cross-cultural aspects, for instance, I'm coming from Turkey, Mediator Vikram coming from India, and Alexandre coming from Brazil. We all come from the 3 different countries, and we have the 3 different cultural aspects. For this reason, especially during the online mediation, not only online mediation, but also whole ADR projects for a process, we have to pay attention to cross-cultural aspects and adjust the cultural aspects and the especially the establish the negotiation dynamics during the online mediation. Let's return to negotiation. During the negotiation, Thomas Valenti emphasized that the gopher and decision model and implications of the use of artificial intelligence in a decision making, and how artificial intelligence helps in decision making. Under his article, he says that parties and their lawyers should firstly identify issues, and secondly, identify their interests, and thirdly, identify their Patron, and fourthly, establish a resistance point, and fifthly, establish a target point within the framework of helping of artificial intelligence in decision making. Additionally, Tom especially referred special models and examples that enlighten the way of academicians and practitioners who work in this area. He also highlighted artificial intelligence alone is not guarantee of a better result, and how not to lose the human factor, in my opinion, is the most important point. And at this stage, we are all questioning why we apply artificial intelligence and whether artificial intelligence represents figure of the authority or helps people whenever needed. I think it's the big question came on our podium. In my opinion, artificial intelligence should be a valuable tool to help party and advocates before their decision-making in the commercial online mediation, complies with the needs of financial analysis of their conflicts. Aside from this idea, in a short while, when I return to my article, depending on my financial and banking background, I emphasized 3 points as follows: what the term of commercial mediation, role of mediator, and the importance of decision tree analysis before decision making by the parties is. For this purpose, I mentioned that looking at a model, legal infrastructure for financial activities and transactions, all concerns need robust commercial law system. Hence, basic banking contracts such as loans and deposits, mortgage-backed or other asset-backed securities, and foreign exchange products require codification in commercial regulations. Banks, insurance companies, financial intermediaries, financial leasing and financial factoring companies especially rely on company law, compliance with the requirements of organization and financing. The development of contracts and securities in commercial law serve to grow financial markets. Concerning complex and high-volume commercial transactions, in the either banking, financial, or other commercial contracts, disputing parties as main actors of financial markets are subject to relevant commercial regulations. From this point of view, small, medium-sized companies or other systemic important organizations or banks should be encouraged to include appropriate ADR clause with their employees and their trading partners. Besides, commercial contracting parties are encouraged to include a virtual type of ADR called ODR clause, along with a traditional ADR clause due to its pragmatic benefits. As Alexandre Simões mentioned before, with COVID-19 pandemic precautions in place, no doubt virtual mediation became a necessity for the banks, other financial institutions and companies since February 2020. Regarding the role of mediator in the commercial online mediation, I indicated that the mediator how should ensure the great ODR awareness and trust, technical accessibility and competence, control identity and digital signatures accurately, ensure data security and privacy compliance with the relevant legislation, and provide neutrality, confidentiality, and relevant negotiation powers, such as worst alternative to a negotiated agreement, wait now, most alternative to a negotiated agreement, make now, or possible alternative to a negotiated agreement, PATNA or RATNA, ratified alternative to a negotiated agreement during the online mediation. In this working, important international ADR centers code of ethics and guidelines and relevant EU directives were inspiring for me. Moreover, I highlighted that especially how to discover the real interests and evaluating and measuring risks and conducting cost and benefit analysis for not only banks and financial institutions and other companies, but also counterparties during the online mediation. Furthermore, both parties and their counsels should learn how to build correct decision tree structure and to do cost and benefit analysis before decision making in the online mediation. At this stage, sectoral illustrations, examples, and evaluations, which I stated in my article, beside my suggestion to get an expert opinion when it is required, will be a useful tool in banking and financial disputes for both parties. I particularly believe that these illustrations, model example and evaluations will be useful for financial debtors in distress. And at this stage, I would like to extend my special thanks to a lovely colleague from Brazil, as I mentioned before, to Vikram, because I used this kind of technique and I referred this technique, Gabriela technique, in my article. And for that reason, I would like to extend my special thank to her. Let's return to virtual mediation. Considering the virtual mediation, as I mentioned above and Alexandre highlighted that, I questioned whether artificial intelligence may help to measure and evaluate options in a sound manner for not only financial party, but also counterparty. Tom Valenti explained to us artificial intelligence participants can achieve financial rewards by putting choices before consumers of goods and information that benefits in his article. Moving forward with his thought, in this context, artificial intelligence may ensure predictive analysis for both parties and lawyers, depending on their needs and interests, and hence both parties may either get third-party opinion or benefit from artificial intelligence when conducting their decision tree analysis in financial disputes. In this respect, the mediator's mission is to help each party to assess its current situation and the alternative of litigation truly and in a constructive manner to discover real needs and interests. Thus, reaching an amicable solution by the parties will not be long distant, under my opinion. As a summary, in my article, I highlighted either arbitration or mediation is a good option than the litigation for especially financial disputes. At this stage, I want to emphasize that, for instance, if parties go to arbitration, they can reach solution in a more pragmatic way via ARPMED, arbitration mediation. For more focusing the another topics in our book, when we return to ethic rules, Zoe shared with me international guidelines and rules were inspired of her during the writing article. She discusses mainly the importance of ethics in online mediation and how complex and challenging issues of application raises questions, inspiring spirited debate in her article. Ladies and gentlemen, as we know, ethic rules is so crucial and necessary for not only in the ODR process, but also in the ADR process regarding all concerns. And let's, at this stage, I would like to explain the Yoshi article. Yoshi looks at the efforts of UNCITRAL, APEC and ICO, as well as European Union, so strongly contribute to the smooth and effective use of ODR, not only in developed countries, but also emerging market countries. In this series of international rulemaking activities, UNCITRAL presented a desirable ODR scheme and identified various issues for consideration. APEC developed the ODR scheme in line with the official model procedure rules for ODR and produced a framework where many countries encourage the use of ODR, and list of reliable ODR providers is provided for users. ICO has now started its project to develop the scheme and rules as worldwide standard and ODR, which includes basic principles, technical conditions, and operational menus in Yoshi article. From the starting point of Yoshi, let's move forward to special ODR platform experiences in Italy. Federico explained what the ODR is and why ODR is necessary, in addition to the growth of ODR and its regulation and effects of COVID-19 pandemic on ODR at the beginning of his article. But the fact that the most important part of the article, titled ODR Platform, the case of Italy, contains more specific applications and techniques for all users. I'm sure that especially compliance with the example of case of Italy, platform to business P2B environment, and European Union regulation of the P2P dispute resolution environment will be inspiring for not only mediation practitioners and advocates in Europe and other countries in the world under his article. Within the framework of enforcement of mediation settlement agreement in the digital era, Professor Nadja, Alexandre, and Vakhtang discusses whether the provisions of Singapore Convention are up to date to reflect the challenges of the digital era. You know, 8 months ago, we discussed what's the importance tools of Singapore Convention on mediation in the digital era, Vikram. For that reason, I'm sure that this article will be inspired for all of concerns, because in their opinion, the success of the Singapore Convention depends on whether states are willing to develop mediation law and jurisprudence that goes beyond the term of Singapore Convention to regulate the other aspects of mediation, such as confidentiality, admissibility of evidence, and enforceability of mediation clauses under their article. Let's return to article of Rahim, that I want to emphasize that. Under his article, ODR creates the possibility of having dual technology and human-led interventions, which are quick, low-cost, party empowering, and relevant for individuals involved in the conflicts. Such interventions should also be able to prevent such a conflict happening again to them and others. In addition, the current notion of borders and differing legal systems will be lost in the online world. And we will see conformity with commercial contracts like cryptocurrencies and smart contracts based on decentralized systems. He referred to United Nations Sustainable Development Goals, SDG 16 rules. For instance, under SDG 16.3 states, promote of rule of law at the national and international levels and ensure equal access to justice for all. Additionally, according to him, access to justice is called a long traveling protected by jurisprudence and international regulations. Considering frequency of engagement, probably in the medium to long term, to a higher level of engagement, it will allow peers to create their own mechanism to create a sense of justice for themselves. In this stage, hybrid model of justice will be created which operate in the shadow of law. The state will not be a framework where we access to justice, but rather than final place for enforcing justice. As a summary, he looks at whether ODR could create exciting new and innovative ways to rewrite the notion of access to justice in his article. Lastly, ladies and gentlemen, from the starting point of Rahim's thought related to decentralization and smart contracts, I'll let you share the application of ChatGPT calls Chat Generate Pre-Trade Transformer, different DeFi projects based on smart contracts, and Web 3.0 technologies which depends on decentralized systems as rising trends in the online environment. I'm sure that the usage of above-mentioned online tools will increase quickly and dominate in our life in the near future. For this purpose, people who govern online process in a good way, they will reach their targets so easily, under my opinion. Before ending my words, especially I would like to introduce what the ChatGPT is. Chat Generative Pre-trained Transformer, commonly called ChatGPT, is a chat box launched by Open Artificial Intelligence in November 2022. It's built on top of Open Artificial Intelligence GPT-3 family of large language models and is fine-tuned and approached to transfer learning techniques. OpenAI currently offers ChatGPT for free on its website. If you are hoping to use OpenAI's language models in a commercial sense, this does cost. Ladies and gentlemen, bearing in our mind that future is not far away, and please be follower of innovations. While I'm ending my words, I hope you should follow and read our book at the first chance. Thank you for your kind patience.
Thank you, Yonca. But Alexandre is going to tell us what he picked up from the various chapters. So, Alexandre, I've opened the index, the list of the chapters. So, please tell us what you picked up from these chapters. Yes, Alexandre.
Well, I did chapter 4, but many chapters called my attention. Yonca did a very good explanation about one point that I think is the most modern one, that's the artificial intelligence use. And I see that what I wrote was also in part of other chapters. Mediating in Digital Space, chapter 3, Mauricio, Gomm, Santos, Azubike, Okoye, for instance, they pass through many points that we talked in our article, but they divide in a different way. They separate the roles of the mediator, then they explain what could be the roles of the lawyer, understand that technology to be used. I don't know if I think that I don't consider myself as a geek guy, as a person that is so used to technology. But I think that the platforms are so friendly, so easy to use, that with a few hours of training, you start to understand how they work. We are at Zoom, we are using the transmission of the seminar in a LinkedIn, in another ways, probably YouTube. If you go to Teams, if you go to any other kind of platform, you see that it's not so difficult to use. Of course, when you are training and use more frequently one, we want to use always that one. But I think that we are going to see many changes in the market. I think we are going to see big companies buying good platforms, and we will be, in my opinion, we will have a concentration of platforms. In Brazil, locally, some institutions like to have its own platform. Nothing against, but I think it's crazy, because you want to have a platform, you want to have the responsibility to update this all the time, and I think if you trust on something that is used worldwide, it's better. So we see here the biggest Brazilian institutions, even the international ones that have offices in Brazil, they use solutions that are from big companies. So they buy from Cisco, Microsoft, others solutions, and let the big company, the big IT company, takes care of the updates. When I start using Zoom, I remember that I was so glad that I was in version 3 point something, and yesterday I updated to version 5.18. So every week there is a new thing, a new feature coming, and very soon what's important about the book, more than going through also the cross-cultural aspect that Yonca brought, because if you have people from different legal backgrounds and different cultures, you need to adapt this. So I think it's good technique, and this book talks a lot in other chapters, to have the mediator talking first, explaining the procedure. And in my chapter and in others, we developed that in the ODR world, the use of caucus is so easy, because if we are in the same platform, in the same day, in the same time, we can create the breakout rooms, separate rooms. For instance, in my first speech, I told that when you go for presentially to our office, they put you in the reception or in a room. Here also, you can have the waiting room. So you are there to everybody check your IDs, your credentials, if you are supposed to be in the meeting. Each caucus, each separate room, we cannot talk with each other. So I strongly recommend, when I am a mediator, that parts don't use the chat unless they know how to use it. Because if you use the chat for everybody will see what is written. So if you do not dominate the technique to use the chat to communicate with the exact person or persons you want, I strongly recommend that you use your phone and use another method that's not in the platform. So you are guaranteed that there is no leak, no problem with the confidentiality. You share devices, you share the whiteboard, you share the technology. So for me, the calculus is amazing. And to assure that nobody is listening to each other, although the platform guarantees that, you can do 2 calculus in the same day. One in very early in the morning, other one 1 hour later, or maybe in the afternoon. So it's easy. And this helps how we build the agenda, because when you need to do a session, a joint session, you need to set the agenda of everybody. Everybody needs to be free at the same time. And as Yonca mentioned, in international practice, we are talking about different time zones. Sometimes it's so good for me to wake up after breakfast and have a session, but my colleague from Singapore, my colleague from India, it's a nightmare, the time hour we are setting. So it's difficult to find a time hour where everybody can be together. But if you do the calculus systems more frequently, more often, you don't have that because it's less people to adjust the agenda. And the duration of the meetings. Online, we do not stay the same amount of time we stay when we are in the presence of each other. Because if I'm with Yonca and Vikram, I would like to speak about the subject we are supposed to speak, but then I want to talk, hey, Vikram, how is your life? How is your golf? Did you make a hole-in-one? Yonca, how is the university? And so we extend the meeting for more than it's needed. Maybe we go after all together to have a coffee. And online, that's not possible. So I think people value more the time they have when they use ODR platform. So the meetings are more incisive, are more direct. The language is more concise, is more precise, because you don't want to stay, and it's a human factor. If you stay more than 2 hours in a meeting, you need to do a break. Your mind will not go well if you stay 3, 4, 5, 6 hours directly in front of a screen. So you need to manage, as a mediator, you need to manage that. Oh, let's make a break, a 15-minute break so everybody can stretch the legs, go around, have a meal, go to the toilets, then we come on with a better mood, for instance. So this is all new, and we are doing this online because we know that online our time seems to worth more. So we need to be very careful. Other good thing is not that ODR meetings have only the time to start. Most of the time they have the time to end. So we have a very tight window. Our meeting is from X hour to W hour. Okay, when it comes to W hour, if you don't finish the meeting, people are going to put in the chat, sorry, I must leave, sorry, and then you are alone in the room. This is another thing that's strange, because when you receive people at your office or you go to a location for an institution, in Brazil, I think it's universal. We say, who is sitting on the top of the table pay the bill. So I say that the hour we all leave. But in online, no. Each of us say the hour we are going to leave because we want to stay at the end. But if you don't respect the time limited, the time frame, people will leave the meeting. The only exception would be that the subject so good is developing so good that a good mediator would say, "Oh, I see now in my clock that we are reaching about the end of the time we prepared for this meeting. Would you like to schedule another meeting, or we can give each other in our agenda more 15 minutes or more 30 minutes to conclude this matter that's so excited, so near to a good point." So you need to be able to have a good understanding on that, do a good reading of the others, to know if it's better to respect the time frame or to extend a little bit, because otherwise you can jeopardize your entire work by making everybody tired and bored of meeting online. With that being said, I would like to do a little table tennis. Vikram, with this point of starting and ending a meeting in a precise time frame, you agree? Yonca, you agree? You have different views, you have different experiences. What you think about?
You know, ask. Yeah, Yonca, please. You made it. Look, is it Yonca or is Yonca? You said
Yonca.
Yonca. It's Yonca. Alexander is Yonca. Yonca.
Don't worry.
Yonca.
Don't worry.
Yonca.
Because every foreigner, can't spell the C, J, and every foreigner say Yonca, don't worry.
Yonca.
She's saying Yonca.
Yes.
Okay. Yeah.
Thank you. Alexander highlighted a so important point in my experiences. For instance, especially every 1.5 hour or every 1 hour, I always give a break to all parties, because he said that after 50 minutes, for instance, during in our webinar, people don't focus to screen, don't want to focus screen much more than, and for that reason, and if we plan, for instance, every 2 hours and a half, for instance, in the lunch break, especially for one hour and a half or 2 hours, because after 2 hours, people want to rest much more time. And the finishing time, for instance, if I use the whole day, finishing time always 5 o'clock in Istanbul time. Why? Because otherwise, after 5 or 5:30 o'clock, for instance, in Turkey, but every country, we will see the same things. After 5:30 o'clock or 6 o'clock, the rush time and traffic will be horrible. For that reason, people don't want to stay in the chair, or don't want to stay in the office, in my office, or in their home. And for that reason, I don't want to disturb you after 5 o'clock. And the another important point that I would like to share with you, for instance, in my part regarding the evaluation, not only evaluation of Mediator, but also the decision-making analysis, decision tree structure, how to build decision tree structure. Before my thoughts, especially, I want to highlight that the Gopher model, the Tom shared in his article, Gopher model, which includes goal clarification, options generation, fact-finding, effects, and reviews. I think there are some crucial tools. If the parties and lawyers will do this, I think it will be so good for them. And another important model is titled decision model, which contains define the problem, establish the criteria, consider the alternatives, and identity. Especially before the decision making, when I turn to my article, I always recommend to all parties, please get an expert opinion for financial disputes from the artificial intelligence, either artificial intelligence or expert firms. Why we need the expert opinion? Because all financial disputes, for instance, banking and factoring, or complex company disputes, we need expert opinion. We need third-party opinion. For instance, as a mediation advocate, always I need expert opinion. Time to time, for instance, I'm coming from banking and financial sector, and I'm lecturer on banking and digital finance law on LLM program. But although I'm expert, but I want to introduce the things what the things goes that to the participants, to my clients. For that reason, I need the another person's comments or expert's opinion. I think the another important point will accompany with the parties. And for instance, in the Thomas Gaultier article, Thomas shared the so important actions and the reactions against the party during the online mediation with a framework of counselor's approach. If the party should not pay attention the important tools or important steps, I think they will not reach amicable solutions via kind effort of lawyers, because this process, although it's called online mediation process, but in the same time normal ADR process. That's the sole difference. This mediation is going to in the online decentralized system, is based on the online centralized system. And in my opinion, not only cross-cultural aspects, but also especially negotiation dynamics. For instance, Batna, Vatna, Ratna, Reitna, especially in the detailed, complex commercial conflicts, people not only see to Batna or Reitna, but also Meitna and Patna or Reitna, because ratified alternative to a negotiated agreement, time to time, will be so attractive for both parties. In my opinion, this tool can use by all parties whenever they need.
Yonca, in the article on the Singapore Convention, what have they discussed on domestic legislation? Have they discussed what domestic legislation should cover and all that? What all have they covered in that?
I don't think so, because Professor Nadja Alexandre gave the global approach, and he criticized. She and another colleague criticized that whether Singapore Convention on Mediation will be up to date or not, because Singapore Convention on Mediation contains the so important clauses in the convention. But in my opinion, although we discussed the 6 months ago, although some clause were directly to online process, but some of them were not related to directly online mediation process. For that reason, I think, in my opinion, and as a matter of fact, Nadja and Vakhtang come from the Singapore. For that reason, in my opinion, they didn't want to bring the national regulation to the audience, because they come from the Singapore.
No, I think there should be one discussion on mediation legislation in the digital era. And specifically, it could be commercial mediation. I mean, that's okay. Because I think that part of it, the way legislation is going, I think there needs to be, maybe there's no understanding, the lack of understanding of what mediation is, the way the countries want to regulate it, the way it is happening. Because, I mean, mediation can happen anywhere. People can be in various parts of the world. And where is it really happening? So how can you, of course, we need enforcement. But at the same time, we also have to understand the dynamics of mediation. So I think legislation should be discussed. I don't know, Alexandre, what do you think about legislation in relation to commercial mediation or mediation in general?
Well, I like when talking about the Singapore Convention, we followed the United Nations trying to produce for the mediation a kind of document, legal document, that could be the same that the New York Convention stands for arbitration. So we saw the efforts starting. The commissions were meeting sometime in Vienna at the United States headquarters there, most of the time in the United Nations headquarters in New York. And in the very beginning of the works, they were talking about conciliation, because in the whole world, we don't have a consensus if the method we use to the parties to reach with the interference of a third neutral part is only a mediation. In some jurisdictions, this word defines perfectly. In other jurisdictions, there is a distinction between conciliation and mediation. So they start talking about conciliation, they change the name to mediation, and they produce, in my view, a very good paper. And if you look close, it's for commercial transactions only. And it's pretty new, and I think it's working well. And in Brazil, we signed it, but we did not ratify it here internally the convention. So we are fighting because each president that comes to Brazil has a different view. So we have now a president that's here for the third time, but he doesn't want to talk with everybody together. They prefer to talk with a small group of nations, and so this is a political issue. But I know that's difficult to put everything. I like Americans, colleagues of us that say, when you try one size fits all, it's never good, because each jurisdiction, each country, each culture has the peculiarity, the difference. But I think to try to organize something in a world level is good, because everybody could sit and give an opinion. And I think that the convention is open. It's not something that closes the relationship, because remember, when we talk about mediation, we are talking about the autonomy of the parties. So if you don't want to stay in mediation, you simply ask to terminate. You don't need even to say why you are leaving. You say, I don't want to stay here anymore. And everything you did in mediation till that time is non-binding, and everything you said is without prejudice. So you are not renouncing any rights. If I gave, for instance, a proposal, Vikram wants 1 million something, and I made an offer of 500,000, and then I leave mediation, he will say, but you resigned it, you renounced it 500. No, we didn't reach an agreement, so nothing is binding. So I think the essence of mediation is there, is preserved. So I'm in favor of the Singapore Convention. And here in Brazil, I'm working with a lot of colleagues to try to convince our government to ratify its terms. So, because Brazil, the New York Convention on Settlement Agreements is from 1958, and Brazil ratified in 2012.
Wow.
We were called the last bride. In terms of mediation, we don't want to be the last bride. We don't want to be the first, but we don't want to be the last. So we have a good discussion saying that's a good document. And I pay my tribute also to the colleagues in Singapore, because I think Singapore made a natural way to receive the name of the convention, because Singapore is a place where culture are mixed. It's very strong. The Chinese, the Malaysian, and the Indians all together in a city-state, a kind of port, and they did a wonderful work to organize this. So they are efficient as the port. They want things going fast, and so I think the leadership is right. And if I had a proposal to do something from other jurisdictions, say, let's try to mediate where or with whom, I would say, maybe Singapore, it's a friendly place for mediation procedures, depending on the cost, of course, but I think it's a hub. Singapore is a mediation hub. We are trying to do the same with São Paulo, Rio de Janeiro here in Brazil, and we recognize that we have a good practitioners all around the world. India has enormous potential because they have a generation of students that are becoming more and more educated and literate in mediation and other ADR tools. And I think it's of course become a major player sooner.
Alexander, you picked up lots of points. You picked up. One second, because he's picked up very interesting points, and why this important aspect of legislation I was talking about. Because Singapore Convention, sometimes, of course, people say this is like the New York Convention for mediation. The important difference which needs to be highlighted is that in the Singapore Convention, the settlement agreement could be signed anywhere. It could be signed by, I mean, it doesn't matter whether it is a signatory state also. As long as the place where you're enforcing it, that country has ratified it. That's the only requirement. This
Yeah.
aspect has not translated into the larger understanding of how legislation should work. Because
Yeah.
the fact is that you can, like I said, you can mediate anywhere you want. And that this aspect should even come up in domestic legislation. I think that's something we need to discuss as how,
Yes.
because yeah, because we've
Yeah.
already, I mean, there are legislations which have happened for whatever reason, they must have been put into place. But today, with the larger understanding of what mediation should be, and this gives us a good direction, the Singapore Convention, that just forget about the place where it happened, forget all about it. Just enforcement is what you have to work on. And of
Yeah.
course, without prejudice, that you spoke about, it should be without prejudice. And of course, you have to have the fact that the whatever happens in the mediation cannot be called into a court as evidence and all that. So those are that is what legislation you should work on. And everything else, I think we let's just leave it to the parties. I mean, I'm saying parties. I now I've used the word participants. I don't use the word parties anymore. That's one important part. But what you said, that is under the aspect of the, okay, I want to walk out of the mediation, I can do it at any time. That's it. That's not what's happening today. What has happened is that countries, of course, basically the judiciary wants to create this whole thing, that this whole mandatory mediation around that. What they now started doing is there are countries where costs are being imposed if you haven't gone into mediation in good faith, even to the extent of saying that there was a reasonable offer, you did not accept it, you can have costs on you. So they're going into absurd directions. I just want to point it out. Maybe it's not the place that we're talking about, but I'm just saying that that aspect we really need a lot of discussion on, because I think it's going into directions which just might not be good for mediation. I don't know what you feel about that.
Yeah, I think I agree with Vikram, because, for instance, in Turkey approach, we discussed the under the Article 4 of Singapore Convention on Mediation, we can accept email, for instance, signing the mediation settlement agreement, or we can use the electronic signature methods. I think at this, for instance, at that point, I want to highlight that in Turkey, for instance, Turkey, if the parties and the mediators can use electronic signature, at that point, this mediation settlement agreement will be but in the Singapore Convention, for instance, under the Article 2 or Article 4, the Singapore Convention simplified clauses for application to for all users. For that reason, I think in Turkish Minister of Justice, for instance, prepared the draft legislation regarding mediation, and 1 week ago announced in my under for instance the articles related to enforcement of mediation settlement agreement, the commercial court will be responsible for enforcing the mediation settlement agreement. Yes, it's okay, but there is no different clauses than to Singapore Convention on Mediation under Article 4, for instance. And I think this approach is a kind of accepting approach in Turkey. Although it should be changed, but in my opinion, nowadays it's so difficult for me. It's so difficult. But I agree with your comments. Singapore Convention mediation depends on the national applications of regulations.
Does it?
Yeah.
Does it? Because it doesn't, I mean, really depend on the national legislation of those countries. I mean, the fact is that finally a settlement agreement signed by people can be enforced in Turkey or not. Can I enforce a settlement agreement in Turkey?
Yeah, for instance, if our commercial court doesn't enforce all the international mediation settlement agreements, what we can do? I think I'm discussing this issue, and for that reason, I think I don't think so. This is gonna be a kind going on, but if it happens, what we will do, and for that reason, I think all regulators from the different countries have, I think, the capture of the main idea of Singapore Convention. Why the Singapore Convention signed it, I think, in my opinion.
Because I think the thing is that the more complicated that the courts are going to make it, they're going to make it more complicated as these things go on, because either we can keep it very simple. These people got into an agreement and they signed it, and now we have to enforce it. It can be as simple as that. But lawyers are not going to be able to accept that, so they are going to take it into various directions. So the practical part of it, what is really happening in Turkey, because out of all three of us, you are the only country which has ratified it. We are just signatories.
Yes, so, in my opinion, yes. I hope so. I hope so. But for instance, the 1 month ago, I participated in another International Singapore Convention on Mediation webinar, and one lady came from the Ukraine or Kazakhstan, and she shared the new legislation regarding the enforcement of mediation settlement agreement under the Singapore Convention on Mediation. I think they were so interesting for me. I think that this legislation were so good, but otherwise, for instance, the Kazakhstan didn't accept the good modification or good regulations under the Singapore Convention. What we can do in the Kazakhstan, for instance?
Because we had a discussion about Kazakhstan with Kazakhstan's ratification with Rusana. It was a nice discussion. You'll find it on the channel. So that was part of the, I think it was part of the World Mediation Conference or something. I don't know where we did that, but we had that discussion. That was a nice discussion. Yes. Alexander, you were saying something.
Yeah, most of the countries in South America, they divided court-mandated mediation from private mediation. In Brazil, we have provisions that you must try mediation. And some judges are using one article of the Brazilian law to say, if you don't come to the first meeting, you will receive a penalty, 2% of the amount of the case will be charged on you. So people go to the first session. And in the first session, they simply say, I don't want to mediate. So the mediation closes and nobody pays the fee. My practice is in the private sector. In the private sector, mediation was designed by the parties and the practitioners. And court-mandated mediation, with all due respect to our judges, to our magistrates, were designed by them. And the need they had was different from the need that the society had. The need of the magistrations is another door to make a lot of lawsuits going out. This is the wish. And in the private sector is the true analysis of your Batna. If I have a better solution to talk with the other party in a table, negotiate it, and find an agreement, and this is better in terms of time, costs, undirected and hidden costs, then the most intelligent option is to sit with the party, negotiate directly, or find a mediator, because the mediator will help in the communication, will assist, organize the procedures. So in Brazil, we are seeing that if you start a mediation, domestic or international, in the private sector, in a private institution or ad hoc, the chances to reach an agreement are much higher than the court mandate. Because at the court mandate, they don't pay well. What they require as to capacitate people is too low. And when you go to the institutes, you see that the people who did 40 mediations last year are doing the 5 in the first month of the year. So they are going to do 60, because the more you do, the more they recognize you, the more they look for you. So I'm a true believer of the free market and the private sector. I think the governments can try to regulate mediation, but mediation, I would compare with an exquisite animal. For instance, let me say, I don't know if you are familiar if the term in English is equidna. It's a kind of duck, a kind of that lives in Australia, ornithorynk. It's a hare animal. For me, mediation is a hare animal. It's not a duck. It's not a fish. It's not a. It's a blend. So you must be very careful how you handle it, because as Vikram mentioned in my view with very good aspects brought. At the end of the day, if the parties want a transaction, if I'm the owner of something, I can donate what I have. If my will is a free will, why I cannot do if the other party agree with me that we are going to do this way? Who is the government? Who is the European Commission? Who is United Nations? Who is someone to say, no, you can't? Huh? If it's not illegal, if it's not harming anyone, if it's not on something that's doing any damage to the climate, to the ESG politics that are now it's the trend, new trend, why not? So I'm a believer that if you reach informed decision, your decision is made with a lot of information, I think you can take the risks and assume that if it's good, it's good. If it's bad, okay, I made a bad decision. I need to be guilty and responsible for the decisions I made. And so I believe that the private sector is the great opportunity to teach the mandate mediation, mandate court mediation, how a real mediation must be done.
Exactly. I'll tell you, the thing is, I've been saying this for quite some time, that the fact that we have created this terminology, court annexed mediation and private mediation, I think we've gone wrong itself. Mediation is what is private mediation is mediation. That is what mediation is. We did not need to qualify it that way, but we had to do it. But Gabriela, she's in Ecuador. First of all, I have to say hi to her. She's we haven't seen her for some lot of time, but she's saying, but if you force someone to go to mediation, I wonder what happens with the voluntariness of the mediation. That's why people don't stay in mediation when the law forced them to assist. Similar sentiments, that basically the fact that if you force them into mediation, it's an issue. That's an issue that by itself is a discussion. Gabriela will have another discussion on that, on mandatory mediation. So I think that's But the important part, which we will keep discussing on legislation also, we'll have a separate discussion on that. That legislation in relation to the Singapore Convention, when you're ratifying it, what all should you be looking at? And whether the experience of Turkey or Kazakhstan or the other countries which have ratified it, practically what issues you are facing. Because it is very nice to say that we have ratified it, but if it is not going to serve the purpose for the people who want to get it to enforce a settlement agreement there, so the issues that are coming up might not be, I mean, okay, in the digital era, we'll take that part also into it, that what legislation and what it needs to take care of in relation to digital signatures and all those aspects, we'll take that. But I think we need to have a discussion, because countries that are in the process of ratifying it, let's us sit together and make a kind of a model law. UNCITRAL has already made a model law, which of course is out there, but practically the issues that people are facing, let's incorporate that and create a model law, and let's circulate that into countries where they are now thinking of ratifying it. Because I see a major issue even in India, because we just, I mean, this is what coming from what Alexandre, the point that he picked up, that the word conciliation. The fact was in 1980, UNCITRAL took out the conciliation rules. We were far ahead of our times. We took those rules and we enacted what we call the conciliation. It's part of the Arbitration and Conciliation Act. We have an act on that. Best legislation, I say, on mediation. Because first of all, what is mediation? That by itself, legislations don't define in countries. There is no definition in our legislation on mediation. What is mediation? So I tell people, look, you have to go into a definition in the Singapore Convention, because we signed it. So we in principle accepted it. That's the only place there is a definition. And when you look at that definition, which is a very simple definition, and I've spoken about it a number of times, and I find myself repeating it, but it's important here because we're discussing it. But this is what that definition basically means. It says, I mean, this is what we need to just look at and then say whether that word conciliation, is it covered in this in our legislation, because obviously it's covered under that, and UNCITRAL has also clarified it that it's the same thing. We were using the word conciliation earlier, and now we are using the word mediation because that word has become popular. Now here the fact is that the legislation is there, that you keep confusing people. The user, I think we are not understanding the user what they need. They don't want these various technical words and everything. They want the process. That's all they want, and they don't want to get confused into the models of mediation and all that. So this conciliation word, because Brazil, I think there is Alexander, there is a particular differentiation that you have made in relation to your legislation on mediation and conciliation. You have something there?
Yes, we have conciliation. Conciliations is called most of the time in the presence, or not in the presence of the judge, but in the beginning of each judgment, in first instance, in second instance, they have a window of conciliation. But to be honest, most of the time, someone came, it's not the judge, it's a clerk, and they look for the parties and lawyers and says, is there any possibility to conciliate it? No. So they prepare a term, you sign, and that's it. Because if you see how, for instance, in São Paulo, the courts have many audiences in one day, many sessions in one day, they leave 15 minutes, 10 plus 5, 15 minutes for each mediation. My speech as a mediator will take this 15 minutes, my introduction. And for me, it's a miracle that a conciliation sometimes produces something, because it's a very short time frame. So in Brazil, we have the distinction in many other neighbors in South America also, but I think the conciliator is someone who has to do magic, because in 15 minutes, how can you hear, understand, make proposal, counter offers? I prefer to say, look, the mediation, we prepare the case together so everybody sees everybody. Then we go to caucus, and then we talk. We come back only when there is a ZOPA, a zone of possible agreement. If I see that the parts are not coming together, why I'm going to put them together to end the mediation? So I think the mediation, in my view, is a very good art craft, and a conciliation is a magical shot. I have one shot. If I found everybody with one shot, it's okay. In Brazil, at least. I don't know the experience around the world. And that's why, Vikram, they changed the name conciliation to mediation when UNCITRAL became to discuss the model law. It could be a model law, a convention, and they decided for a convention, and the UNCITRAL model law on conciliation became the Singapore International Convention on Mediation in a very short brief.
Because I'm here, I keep talking about it only because of the fact that that word, people have picked it up and saying that we don't have a legislation on mediation. I find that very sad, because have you even gone into the history? What is that legislation that we have? It's called conciliation for a reason. And of course, the other discussion that I've been having is that we need two words. We need mediation and conciliation as separate words. You can call whatever words you want to use, but we need both of them, because there are situations where you do not need a formal law to go, because people are going to be mediating all the time. They might have oral agreements. Oral contracts are also contracts. That process will also keep happening. Yeah.
In our communities right now, there is a lot of conciliators that are not law professionals, that are making a good work, making the community working. They are naturals. They are there talking with the schools, talking with the kids, talking and arranging things in the neighborhood. So you don't even need a profession. I don't see conciliator as a function, a formal function. If you are the kind of person who wants to make a point of view for the others with the third side, with a more inclusive side, you are a natural conciliator. We need a lot of conciliators in the world, but I think we don't give them the necessary attention they deserve. The mediators are now, I think, in terms of being well paid, the arbitrators are the well paid, very, very well paid, and mediators come second. In between them, we have the adjudicators, the dispute board people that works for construction mainly. But I don't worry if it's going to be a regulated profession, it's an occupation, but I think we are all talking about having a good toolbox with ways to solve problems. We need to have many tools to solve different problems, different aspects, directly with the power of a judge, the power of a state, or with the free discussion of the parts, and if they reach an agreement. I agree that sometimes to demand a lawyer is too much, but we here in Brazil, we had bad examples. For instance, the banks called old clients to settle debts, and the clients were happy because they said, oh, I was owing 1 million and I settled for 1,000. But the debt was not able to be pursued in court anymore due to the time. There was no right. So when you reveal to the guy that was so happy because now he has the good name on and he's not owing 1 million, and he did I will pay 1,000 in 10 installments of 100. But one lawyer comes and says, but this is not a debt anymore.
What I need to do? Yeah.
Yes, that's why I defend that you don't need a lawyer, but in commercial transactions is very, I would say it's a good practice to have a lawyer with you, because sometimes you are the owner of your rights, but if you don't know the law, you can do bad settlements, if I can say. One thing interesting in your speech, Vikram, it's the judge saying, you refused a good offer or a reasonable offer, I think was what you said, that I heard from a lot of judges. For me as a mediator, how difficult it is to put this adjective, offer is reasonable, because it's not for me.
Exactly.
It's for the other.
Exactly.
It's reasonable if the others say so.
Exactly. That's what I'm saying, Alexander. When you read those judgments that have come out, it is absurd. I mean, even Singapore in its own legislation talks about good faith, that whether you are going into that mediation in good faith, who's going to decide that good faith? Finally, the judiciary has taken it over. That is, and they have a vested interest, definitely. But I always go into this direction. But I've said, Gabriela, yeah. But Gabriela, that's one question she's put in. I've of course sent her the Zoom link also. If she wants to come in, she can come in. But her question basically is about what I mentioned about that. She's saying in Ecuador, conciliation is part of a trial. But as you said, some countries use conciliation as mediation as similar words. So again, let me just clarify that we have a legislation on conciliation, and that conciliation is mediation. So first point is we have to start with the basic definition of mediation. What is mediation? If your own domestic legislation clarifies it separately, and maybe like in Brazil it does, or maybe in Ecuador it does, if it does that, then you have to follow that. But if your country doesn't have a definition of mediation, where are you going to look for a definition of mediation? So as a signatory country to the Singapore Convention, we have a place to go. So I go there. I look at that definition. And I say my conciliation, that legislation I have, is mediation. And say Uncitral clarifies it in the model law very nicely. It says that, like I said, we were using that term, but they're interchangeable. They do that. So I'm just saying that we need to have a discussion on legislation, because there might be confusions in other countries, because if you are going to be, if your basic understanding of what you're legislating itself is different, so where are you going to go? What direction are you going to go?
Yeah, yes, for instance, in Turkey, we don't have any mixture conciliation and mediation system, as the Gabriela said that. For instance, we always use conciliation in the criminal matters, as a conciliator, for instance, as a conciliator, conciliator play the so important roles in a criminal matters, in a criminal case. And the another point that, for instance, under the civil procedural rules, the one article of under procedural rules, at the beginning of the trial, judge have to ask to the parties, you want to conciliate or not, whether you want to conciliate or not. But in our procedure, always they did not want to conciliate, and for that reason the trial has been continued. And in my opinion, I see you totally, Vikram, because you mentioned the so important point, and you highlighted the conciliation and the mediation. I think is a mixture process. In Turkey, we understood conciliation and mediation is a mixture process, but we don't have separate clauses in our mediation code. For instance, at the beginning, but as a matter of fact, we are our system a little bit closer to Brazilian system, although is not called the court mandated mediation or court referral mediation system. Our mediation system, you know, we have to depends on we have to meet the mandatory mediation first meeting, and all parties have to participate in the process. And if the party will not join the mediation meetings, our mediation systems, I think, give the penalty during the court trial. And for that reason, I think we can. I'm not sure whether we can accept the another conciliation clause or not, because our mediation systems depends on conciliation. Although we don't have the separate clauses, for instance, similar to Brazilian experiences. For instance, at the beginning of the mediation meeting, as a mediator, we will not ask to the parties in a 15 minutes whether you can deal with the another parties or not, deal an agreement or not. But in our process, in 15 or in a half hour, as a mediator, we always tell the procedure, how it works, how the mediation get benefit to the parties and lawyers. And after, especially in our mediation speech at the beginning part. But after that, for instance, if the parties don't want to continue, we will not continue. That's the basic.
Now, what we'll do is we'll have this is of course a whole discussion by itself. We'll, of course, today be talking about the commercial mediation in the digital era. So this artificial intelligence aspect, that's an interesting area to discuss.
Yes.
Have any of you actually had discussions with ChatGPT? Have you tried conversations with it?
Yes,
Great fun.
I tried. So interesting.
Alexandre, have you tried? Alexandre, have you tried that?
Well, what I would like to say first is thank you for our colleague from Ecuador. I would like to say hi in Spanish. Buen día, ¿cómo estás? Es un placer tenerla acá. I'm ashamed because Brazil I would like that Brazil had followed the example of Ecuador. Ecuador ratified the United Nations Convention and the Singapore Convention 2 days before September 12th, 2020. So it was one of the first to ratify. So I think you have this possibility. You don't have a national law in Ecuador, but you are part of the Singapore Convention. So you can keep your local law for what is conciliation and use the definition of the Singapore Convention to construe one day, if it's necessary for equatoriality, a law on mediation, Equatorian law on mediation, or simply continue to use the definition of mediation that you can find in the Singapore Convention.
But on the Chat GPT, anything on that, Alexander? Have you had a conversation with Chat GPT or not?
Conversation about, sorry?
With Chat GPT, when you're talking about artificial intelligence today, that's the conversation around Chat GPT, which is happening.
Yes, I confess to you that I was worried a few years ago when I was talking with an English colleague, and he mentioned me. Today, we have the first decision in a mediation that was suggested by a machine. The machine suggested, look the verb, the best outcome. Then the parties looked at the suggestion and realized that the machine was right. The best outcome for everybody was designed by an artificial intelligence. I think that's easy because the machines cannot feel the emotions. Our problems to have a perfect rational decision is that we feel, we dream, we have impressions, and that's important because without that we would not be humans. So we are humans. We feel, we're satisfied, we laugh, we cry, and for me, I confess, I'm a little bit afraid because machines can be programmed, and if we believe. I will do a little comparison. When the calculator comes, everybody say the next generation will be dumb in mathematics. The calculator is just a tool. If you use it correctly, you will still can develop your mathematical skills, your algebra skills. The Indians are a true proof that they can be developing on that. So the same, I think, will happen with the artificial intelligence. When I was young, I need to look for books, encyclopedia. If you are a rich person, you have a good encyclopedia. If you're not so rich, maybe you have a medium encyclopedia. The number of chapters, the number of books, the volumes proves that. When I was young, it was a dream to have a full set of the Britannica. The biggest encyclopedia at my time. Now, you don't need an encyclopedia. You go for the Google. You go for the searching machines, the search engines that we have. But again, who is furnishing the information for the searching engines? Because today there is a lot of information that's, sorry, my French, it's bullshit. So you need to have the fountain to know where are you I'm drinking for a pure fountain. If I trust the fountain, if I trust the work, the persons who are selecting or the mechanisms, I can trust the information. Otherwise, it's just a narrative. It's just a distortion of something that's not a fact or not a piece of information that's important for me. So the challenge is, I'm afraid, but again, it's undisputed that we are going to have more and more chatbots, and we are going to talk more with artificial intelligence in the time soon. So it's inevitable, in my view. If I have fear or not, I will need to go for this challenge again. I don't know if Yonca and Vikram think about.
Yes, Georgia, what do you say?
Yeah, it's so challenging issue. 10 days ago, we discussed in the ABA meetings, and one of our colleagues asked to us, I don't want to use ChatGPT because, in my opinion, ChatGPT sounds a kind of authority, and change the human kind. In my opinion, I don't want to accept a kind of authority as ChatGPT, because if people govern the artificial intelligence, I think I cannot imagine the near future. Otherwise, artificial intelligence dominate the all part of our life, all functions of our life. I don't want to do this, I think. In my opinion, especially in my article, and the Thomas Valenti, they shared the same thought. Whenever people need artificial intelligence, especially, for instance, during doing financial analysis before decision making, please, you should apply the artificial intelligence. Please get an expert opinion. Otherwise, it's not acceptable. I cannot accept the functions of artificial intelligence. I cannot accept as a figure of authority.
No, but I think the thing is that we're talking about artificial intelligence, and if you talk about it in relation to mediation, artificial intelligence just picks up from data that it is getting access to. Now, today, mediation data is not available. I mean, either you are that the entire proceedings are available for a machine to observe and pick up from, and then learn from that. That aspect is not available at all. So either should we make it available? Should all mediations be recorded and a transcript going into a machine, and that using it further to improve its own understanding? If that access is given, then we can talk about artificial intelligence in relation to mediation. Otherwise, it's just general information that you'll get. Because to actually see that, look, today we have, I mean, you can actually, with those cameras and everything, with whatever that, what people are feeling, you can put machines for you to check that also. Everything can happen. You can actually have real-time experience of how the person is reacting. So if we have all that, when you put all that data into a machine, and then that machine learns, and then artificial intelligence used, then we can use it in mediation. But today, that whole confidentiality aspect, that we do not even want the basics to go out, how are we going to look at mediation and artificial intelligence? That's going to be a little bit
from the angle of the confidential agreement, it's impossible that you highlighted.
So either everyone agrees that we are trying to make this world better, and we want, people are not being able to mediate, we need machines to mediate. So all of us are going to give access to all mediations to machines. They can learn what they want from it, and maybe they'll come out with better things. So So, but now what I've understood from your book is that we need discussions on each of those aspects. Of course, the Singapore Convention has been discussed enough, but the practical part of actual the ratifications that have taken place in those countries, let's have a discussion from those countries. I had that discussion in Kazakhstan. Similarly, we'll have a Turkey and Ecuador, and of course the other, Qatar, Fiji, Singapore, whatever their experiences, practical ones, so that we can come out with. And then, like I said, the second part, that a legislation, how the legislation should look like in the digital era, because obviously we are sitting in all parts of the world today. And that part, what other points have come out for our discussion? Anything else that you people think that we can have separate discussions on? Artificial intelligence, definitely. Legislation, Singapore Convention, for the practical parts. Anything else that you people suggest? Because I'm always waiting for topics. Alexander, what are you telling me? What are you?
I send you in the chat. I know that our audience cannot see an image that represents the same ceiling of the Vatican. We have the finger of God touching the human being, and I received one with the God being replaced by the machine. It's so disturbing for me, but again, I think the problem, as you proposed, due to the fact that most of the procedures of mediation are under confidentiality, are secrecy, we can record and send to the machine, but we are going to break this promise of confidentiality. So I think we are going to have this machine is learning, but again, the machine learns what you serve to it as an input. The problem is that humans, we lie, we dream, And so far, the machines cannot understand why we are not in the rational way only. Why our brain is not only the rational decision, because we have feelings. And so I think the most difficult part is to teach the machine how to feel and to discover when something is not true, but it's a maneuver, it's a way to manipulate. Thank you, Vikram. This is the image now that you can see.
Yes.
The fingers are touching, creator and creature. And it's a proposition saying that, look, I will give an example. Today, every day when I woke up, my alarm clock is in the cell phone, in the mobile. The first thing I'm doing is to look for the messages. I did not brush my teeth. I did not have my breakfast. And I'm looking if I had a message from last night till the first hours of the day today. This is wrong. This is dependency on the technology in a way that it's going to create bad habits for us. So maybe what we need, as my word about artificial intelligence is, or we keep being the creators of this technology, and we don't let the technology dominate our life. Otherwise, I think we will be becoming too dependent on technology, and then we'll forget our natural skills. If I don't have a calculator, but if I have an abacus, or if I have a pen and paper, I can do some calculations. It's important to have these basic skills present all the time with you. The same with communication, empathy. I cannot see how a machine can be empathic. When they look to the robots in Japan, they trying to do the robots with our faces. It's so scary because they don't have hair. Sometimes you see some wires, some chips, and they try to do the movements, but to give a laugh, it's a lot of muscles that you move in your face. And your brain made you laugh. So it's difficult. But I cannot say it's impossible. So it's the challenge of a whole new world. I hope that we keep dominating technology. Isaac Asimov mentioned the law of robotics, that a robot cannot become against or harm a human being. I think this law be respected all the time.
Definitely.
Lastly, I don't want to disturb all participants because 2 hours, yeah. Lastly, I would like to share with you not only ethic rules, but also ODR, whether it creates access to justice or not parts. And for instance, the Italian and South American experiences will be so effective parts for all concerns. And please touch upon this book and order this book from the LexisNexis French sites. I think all users like our book, in my opinion.
I think this is another important point that you picked up, and we have to have a discussion on it, because people say mediation is access to justice. I have my views on that. I think we'll have one discussion on this aspect, because very casually it is said so, but how do we have to look at it? My sitting at home and resolving a dispute with someone through mediation, is that access to justice, or am I doing it because I don't have access to justice and because justice is denied in courts? That's why I'm doing it. So that's a whole discussion by itself. So yes. So let's wrap it up, but before we finish it, let Alexandre give his, of course, some final comments. Alexandre, anything that you want to give your final comments?
I prefer to call myself realistic optimistic. The challenges will come, the problems will be different, but us or the next generation are able to solve it. I always, my mind is set in a way that I'm always confident that we or the new generation will find the solutions that our world needs, that our planet needs. So I think it's welcome new technology. And let's not forget that we created this technology, so we must dominate this technology. Otherwise, we will be dominated by this technology and we will lose a lot in our lives. If you have the possibility to access the book, please do so. Write to Yonca, me, or Vikram. That Vikram will send us the comments so we can know if we are okay with the themes we explored, or if we need to go further on and do a second edition with more things. Okay. Thank you very much for the opportunity.
Thank you, Alexandre. But Yonca, you will get the last word. Before you give the last word, let me let me put up next week what is coming up. This was the book that I had, of course, I'd also contributed to, which Sarah Blake in Australia had taken out, Mediation Beyond COVID. So
yeah, congratulations.
Yeah, so yours, of course, is looking at the commercial mediation digital era. This is about people giving their stories in relation to what happened during that period. So that's coming up next week. But this is in 10 o'clock morning India time, because a lot of the people are from Australia and Southeast Asia. So we're doing it in the morning. But please, you can watch the recording. So that's coming up. Let me also say that there is a symposium on language and mediation, which starts on the 15th. So please, if you want to participate, please get in touch. Alexandre, Yonca, if you want to participate, please tell me. So that's coming up. And on 24th of February, we have a discussion on mediators and the war in Ukraine, because on 24th February is when Russia invaded Ukraine. So we are going to have a discussion on that. Experiences of mediators, their personal experiences. Some of them have had to move out of Ukraine, their experiences outside. There are people working with refugees from Ukraine, and they've created, I mean, as mediators have gone down, like Alexandra was in part in one of my that mediator experiences. She's spoken about her experience at the Poland-Ukraine border. So any experience that you have in relation to the war, please, we'll have a discussion on 24th. Get in touch. So my job done. Whoever wants to come in, Yonca, last word, final word, your word, whatever. Please.
Yeah. Thank you. Firstly, because we are so close to all concerns via kind host of Vikram, and for that reason, thank you so much. And in my opinion, capturing the future is not far away, is not so difficult via using online platform, online decentralization system. For that reason, please follow of us, and hope to meet you again another series. And thank you, Vikram, for your kind host.
Thank you
and
very
thank
much.
you, Alexandre.
Thank you very much for taking out so much time. And like Alexandre said, sometimes the conversations are going so well that you just want to continue them. So we did that. So thank you very much. And of course, please participate, and I'll see you soon whenever that happens. So